Good afternoon, everyone. This is Jodi Daniels, and we're going to get started with our webinar, Explain Like I'm 5, GDPR Updates and CCPA. So if you caught the first version of this that we did back in December 2017, welcome back. It was popular. We thought we would do an update, and while we're at it, we're going to add in what you need to know about CCPA, the new California privacy law. My name is Jodi Daniels. I'm founder of Red Clover Advisors, a privacy consulting firm based in Atlanta, and we're really glad that you are here today. If you're not already part of Better IT, BetterCloud's Slack community for IT professionals, you can join it at betterit.cloud. You can join the webinars channel to ask questions, discuss the webinar, and meet other professionals. So I encourage you to definitely join the channel. So a little bit about myself. As I said, I am the founder of Red Clover Advisors, and we are a privacy consultancy that assists companies with GDPR, CCPA, other US privacy law, and my favorite, where there is no law, helping companies think through the gray zone and really managing data through the ethical use. I used to work at Bank of America as the SVP of Enterprise Privacy Compliance, and I got my start in privacy by building from scratch a privacy program at Cox Automotive. I come with more than 20 years of business experience across a variety of roles, and I have 2 young children, so I am very used and accustomed to try and explain things in simple terms, and that is truly our goal here today, is to be able to break down these complex regulations into simple, understandable terms. And to get started, we'd like to ask a quick poll question to you. So you all should see a poll on the screen. We're collecting our responses. I'm going to give it just a little bit more. Okay, so it looks like about half the audience has not started yet, with about another 21% or so who have started on their internal policies. Well, I appreciate you participating. Kind of gives us a sense of where everyone participating here is in their preparations. So I really like to look at privacy laws and compliance as a way that can help the operation of your business. It truly can be a competitive advantage, as well as make your business and company more efficient. In helping companies with their GDPR compliance, we've seen activities where data might have been all over the place. For example, maybe they were using plain old Outlook to send their marketing messages instead of utilizing all of the tools at their disposal. Because of GDPR, they could no longer do that, and instead needed to utilize all the marketing tools. And as a result, they can then analyze the information that they have more effectively. They understand who they're communicating to. They can target the right audience. And from a competitive advantage standpoint, I have seen companies gain clients because they have privacy ready at their fingertips, and others who have lost clients because they were not able to agree and say, yes, we have managed and can agree that we are GDPR compliant, or we have a strong privacy and security program. So the companies that take privacy seriously, utilize it in their marketing and communications of their business, will have a competitive edge over the companies that do not. So why should everyone care about privacy? Well, I have a few philosophies. First is from a legal standpoint. Privacy is sweeping the globe. We're all familiar with GDPR in the EU. GDPR has some cousins, if you will. There's some draft form in India. There's a version in Brazil that is effective August 2020. Canada already has some extensive privacy laws, and they are continuing to review those to ensure that it meets the needs of their residents today. And we have in the United States, the California Consumer Privacy Act, CCPA. There's about 9 to 10 other US state laws that are on the docket. You might have been following Washington State. That had passed the Senate, but just last week, it actually did not pass the House. So as of now, Washington is closed. It's been said that they'll bring it up most likely next year. There are still, as I said, a number of other states in the United States who are looking at a CCPA-like bill or something similar to it. And there's also conversation of a US national bill. And I'm asked all the time, will we have a US national bill? There's a variety of industry groups who are looking to have something like that. My answer is if it's thoughtful legislation, it will take some time. If we have some politics at play, it's a dart and we'll see what happens. But more importantly is that the customers we're serving care about privacy. More than 2/3 of them say they would like to do more, that they want companies to do more to protect their privacy. They're in support of regulation from advertisers. They don't feel like there's enough regulation in place to protect them. Less than 10% of social media users feel very confident that they are protecting their data. And about half of those users are not at all confident that data is safe when they hand it over to a company. And to me, those are really important statistics. Each company here is in business to provide a product or service. And ultimately, we're processing personal data of our customers, of employees. And if our customers don't feel comfortable and safe giving us this information, then why would they choose to continue to do business with them? So think about when you go and you purchase something, you want to make sure that your data is going to be safe. It's not going to be misused. It's going to be protected. And if you're hesitant about that company, you're probably not going to purchase from them. And instead, you'll look for a company who does take it seriously. So on that note, when we compare Apple to Android, that's a really good example of a company that puts privacy front and center, trying to utilize it as a competitive edge. And there are customers who specifically pick Apple because they know that Apple is considering their privacy at the onset and has built it into their products and services. Contrast that with Android, where people feel like, no, that's a little bit more open. It's meant to be an open platform. They don't have as many rigorous controls in place. I don't feel as safe. And so customers who value privacy, which as we can see is increasing, might be less apt to pick an Android device and instead would pick the iPhone. Now, something also not here on the slide, but a fun story, maybe after this webinar, Google a recent Discover Card commercial where there's a talking bird. I love when they always use birds in commercials. And that talking bird is communicating the social security number of its owner. And so the commercial is about Discover Card's service to be able to protect your social security number. So one time during a prime TV slot, so between 8 and 9, I was watching TV, and in one commercial break of the 4 commercials, 2 of them were for privacy. One was Apple and one was this Discover Card commercial. I think that's pretty staggering to see that of that very expensive time slot, we have companies who are choosing to promote their business and that they put privacy and security first. They're doing that because they recognize that privacy is good business. Customers who choose companies with privacy and security are going at their forefront will be more loyal. They know that those companies take privacy and security and their compliance with any type of privacy laws seriously. Customers are also looking at how privacy is baked into the website design. So as they're giving information, is it clear about why you want that information? Imagine you go to a site and it's asking you for your birth date. Well, you might wonder, why do I need to give my birth date to a site that never needs to know my birth date to actually give me the the service it's going to offer me. So when you find the site that has maybe the little I or a little extra language around it that explains, well, we want your birthday so we can send you, coupons. Okay, well, that makes sense. And for this audience, birth date is a bit of a sensitive data field. We don't want to collect birth date everywhere. So it's really important to be thinking about the privacy and the security when we're designing our sites. And when we do it from the customer-centric view, we're probably increasing our likelihood to get that individual to give more of their data that will allow us to serve them better. And finally, choice and preference are critical. This particular piece is a little bit more marketing focused, but it's really about almost any metric, because so many companies are focused on the numbers and how many users do I have and how many are on my list and how much data am I processing. Well, we also have to remember that that is an individual. These are people. They're not just metrics, but they are our customers, our lifeblood of our business. And when we provide them choice and preference, as well as really focusing and treating them in that manner, then they're more apt to stay with us for the long haul. So I want to just recap for a moment and make sure we're all in agreement on personal data. When we think about it from a data breach perspective, especially here in the United States to date, it's often been about name and an account information or name and financial information. It hasn't necessarily always been my age, my occupation, my education, nationality, my visa information, criminal background, travel information. All of that is included in the definition of personal data as defined now from GDPR and also under CCPA. The CCPA refers to it a little bit more like personal information, but they're essentially the same. And further, what personal data, personal information really do in these two webinars is expand the definition to also include online identifiers. So all those IP addresses, cookies, geolocation information, ID number, and any other type of tracking information, all of that is now also in scope for personal data. And as a quick reminder, sensitive personal data, especially in the EU, are things like race, ethnicity, political opinions, religious, health, genetic, biometric data. And as a quick refresher, privacy in Europe emanated really quite strongly after World War II. And if we think back to what happened in World War II, they don't want that to ever happen again. And this type of data was really used to profile individuals. So again, if we think about the people, our customers that we're processing data on, or our employees, if we have employees and have to comply with GDPR as well, then we'll start to understand and think about the data that we have from that mindset. And I think that's really important to understand the why and what type of personal data we're caring about as we think about our requirements in these laws. And also, as a quick reminder, to process any data under GDPR, we have to have one of 6 legal grounds: consent, legitimate interest, contract, legal obligation, public authority, and vital interest. Most companies I know generally rely on the first row, consent, legitimate interest, or contract, to ensure that they can process their data. And with consent, we'll talk a little bit about some of the lessons that are coming out from various fines on consent, because what consent means under a GDPR definition is extremely specific. Contract, you have a specific contract in place with your customer that you need to honor. And legitimate interest, often companies look at that as sort of the catch-all bucket. Well, it's, I need to process that data to perform this function in my company. However, to ensure that companies don't use it as just sort of the empty basket for everything, there's a 3-part balancing test that companies are supposed to go through. And it's really meant to ensure that when you're using that data, you're thinking of that individual first. So if you want to use that data to analyze their activity, their shopping behavior, not just from a third-party analytical view, but you're really trying to understand how they interact with your brand and what they're purchasing. That's a legitimate interest potentially. So you would go through and figure out, well, what type of data is it that I'm using, and what could the risk be to that individual? And net, you determine that there's no net increase to that individual very way. But it's intended for us to think first before we just use data. And as a brief reminder, every single element of how you process data under GDPR has to have one of these lawful grounds under it. So you might recruit somebody and onboard them. Those are two different processes. You might analyze the diversity of your workforce. That's yet another processing activity. Each of them are separate and unique. So let's look at GDPR to date. And I just picked a few of these. So first, some of them have big fines, some of them don't have fines. And I think that's also really important. So Google is the big one on this slide. They incurred a $57 million fine for violating consent. And we'll talk in a few minutes a little bit more about some of the consent pieces that they did. Some of these on the slide, like Vectuary, Timo, and Bisnode, are in the ad tech space. And essentially, they were either collecting data that they shouldn't have been, or they didn't have the right consent and weren't able to prove consent for every single ID that they collected, or they didn't provide the right notification to the individuals. So Bisnode, as an example, was levied a 220,000 euro. They are a Swedish headquartered digital marketing company. They scrape data. And the concern there was, did they inform all the individuals of who they're using that data? And that goes back to one of the obligations under GDPR, is to make sure that if you're processing data on someone, that they know that you're doing that. So in that particular instance, it's not millions of dollars, but it's more around there is a fine, and they have to really look at their entire business model to determine, can they keep doing what they're doing, or do they need to notify the individuals? Vectuary is an interesting one. They did not get a fine, but instead they essentially had to completely start from scratch because they're saying that they don't have the proper consent on their users. So they had 67 million users from 32,000 apps, but they couldn't point to the actual contracts. They kind of bundled it all together. And this is a very poignant case in the advertising industry. So not so much from a fine perspective, but from setting precedent of what consent needs to look like and how companies need to manage that. There's a variety of other really small other companies that have had either notice or fines for not having proper contracts. So they don't have the contract in place between them and some of their suppliers, or the right contracts in place with some of their customers. So again, it can be the big items like consent, notification, but it also can be some of those internal processes like the contracts. Facebook is in the news for a lot of things these days. You might have seen the news yesterday, not from a GDPR perspective, but from a US government Federal Trade Commission, between $3 to $5 billion. But in a GDPR state, they actually had a data breach last fall that they announced. So that is under review from a GDPR issue. And there's also some really interesting Google and Facebook antitrust issues that are happening in Europe. So not quite GDPR, but it kind of is tied together because essentially you have to agree to the terms of Google and Facebook, which is using all of their data to receive the service. And yet there really aren't other alternative options. And so it's a bit of an antitrust situation, but that antitrust issue is because they're how that company is utilizing the data. So hopefully that makes a little bit of sense. Some other things, we've all probably seen the ubiquitous cookie banner everywhere. The Bavarian DPA, so that is a German data protection authority. Kind of think of it as like the German Attorney General. They went and, well, one of the parts within Germany, they did a sweep of about 40 different websites, essentially finding that many of them are not managing consent properly, in short. And we'll talk about that in a minute. So what are some of these learnings to date at a high level? So privacy information should be easy to find. That was one of the knocks on Google. It was hard to find all the information about what was happening there. If you're relying on consent, there can be no pre-tick boxes. You must specifically consent to the purpose that the user is actually opting into. You can't have a catch-all consent. So if your company is using consent to kind of be this consent for everything, then that won't work. You need to break that up a little bit more. Again, it has to be informed, specific, and affirmed, and truly businesses of all sizes are impacted, from small to enterprise. So I want to switch gears to the California Consumer Privacy Act. So it applies to businesses that do business in California and processing data on California residents. And here there is a threshold. You have to meet one of 3 criteria. Either first, you have annual revenues of $25 million or more. You essentially collect data on 50,000 consumers, households, or devices. So if your website collects more than 50,000 unique visitors, you're likely in scope, or you derive more than 50% of your annual revenue from selling consumer personal information. And we're going to talk about the definition of selling here in a moment. It's really important. First, I've had some people tell me, well, I don't sell any data, so CCPA doesn't apply to me. This law is not only about selling data, it's just a component. And it's a component because this law really does come on the heels of Facebook and Cambridge Analytica last year. It was passed in June 2018, and it's effective January 2020. So if you kind of, again, understand its origin, it helps to understand why there's such an emphasis on notice, choice, and what happens when companies sell data. But if you don't sell data, you still have to comply with CCPA. Now, if any of you have to comply with HIPAA or GLBA, the Gramm-Leach-Bliley Act, so any financial services companies, that data that you have to comply with those federal laws with is not in scope. However, that doesn't mean your whole company isn't in scope. The rest of the data might be. So for example, your website data might be in scope, and just your main business service line might be out of scope. So what happens if you don't comply with CCPA? Well, there's some regulatory fines, up to $2,500 per violation, up to $7,500 per intentional violation. And what's I think really interesting is that there's an individual right of action of $100 to $750 per infraction if there's a data breach, if essentially no reasonable security measures are employed. So of course you might be asking me, well, what are reasonable security measures? Well, CCPA didn't actually define what it means by reasonable security measures, but in prior California Attorney General releases, they often refer to the CIS controls, the NIST framework, and from a data breach perspective, it's around, if you encrypt data or redact data or anonymize data, then that might not be in scope from a data breach perspective. So the more you encrypt and protect data from that capacity, then you would be employing reasonable security measures. To me, some of the biggest compliance consequences or non-compliance consequences would be your brand reputation, your loss of customer loyalty, and of course, the negative PR. So if there is a data breach, but also if you're misusing data, there's going to be PR around that. And as a result, you might lose customers. You might lose customers who might not even sign a contract with you if we're not able to be able to, yes, we're compliant. And that all suffers our brand reputation, and everyone has a role in ensuring that we're maintaining a strong brand in the company. And I'd much prefer to see everyone on the front page of a newspaper or digital newspaper for all the amazing, wonderful products and services you're offering. So let's talk about the sale of data, one of the really important parts of the CCPA. So first, you have to notify your users that you're selling data. If you're collecting data from minors, they have to opt in. I mentioned that mandatory do not sell link on the homepage. You also cannot discriminate based on the fact that I opt out of my data. So if Jodi says, I don't want you to sell my data anymore, you can't say, well, I'm not going to serve you anymore, or I'm going to charge you 3 times the price because I can't sell your data. You can't do that to me. You have to treat me equally. Now, you can still have a loyalty program, and that's actually one of the amendments from yesterday, but that's very different than I'm choosing to opt out of the sale of my data, and you want to basically discriminate against me for doing that. And this definition is extremely important because selling does not only mean just the exchange of a dollar for dollar. So a lot of times we think selling is you give me this data, I pay you this amount of money. Instead, it means selling, renting, releasing, disclosing, disseminating, making available, transferring, otherwise communicating orally for monetary or other valuable consideration. So essentially, if you're receiving data, or maybe you're the senders of that data, this kind of works both ways, that might be in this definition, then you have to think about the impact to you from selling data. And if Jodi says, I don't want you to sell my data anymore, how will you as a business manage that? Do you know where all of your data is? What will the process be? Do you have to notify any other people, other third parties, other companies that you might have been working with? And how will you communicate that? Maybe you have to update your contracts. Maybe you have to review your contracts to see if any data that you have going back and forth even qualifies with this definition. So this is a big piece of the CCPA, and highly encourage companies to get started on understanding their data early. And I mentioned around children's data. So if any of you sell children's data, keeping in mind what I just said is the definition of selling, then this requires consent. So basically, if you have kids under the age of 13, they have to have a parent opt in. And if you're between 13 and 16, that child can opt in directly. A bit of a recap for those of you who might have joined us previously for GDPR individual rights. I did include them as separate slides. So we're going to talk next about the California individual rights. But under GDPR, making sure that you can honor if someone makes one of these requests. So I want to know all the data you have on me, or I want to change the data that you have. I don't want you to keep it anymore. I want to delete it. I want you to not process in a certain way, or I don't think you should process it in that way. I want to port the data. And then in some situations, if you're making decisions on people in an automated fashion, I might be able to say, I don't want to be evaluated that way. So I need to be able to easily communicate to the company one of these. So is that a link and a privacy notice? But more importantly, how does the company manage this process? Where does the request go? Who in the company makes the actual deletions or changes in a system or a database? That's really important. And I highly encourage companies to test this process out, because what you have on paper might not mean what actually happens. And employees change roles, new data and new vendors come along all the time. So it's really important that we test it. So also from a CCPA perspective, very similar rights. And you'll have this recording, you can go back. The top two are probably the most unique, where in the privacy notice, we have to disclose the categories of data and the sources and third parties that we share them with. We have to know all of the data, and in doing so, then we can update and work with our teams to update our privacy notices. So this is my only really boring legal slide in here. That's very boring and detailed, I know that. But the one piece I want to clarify that we haven't really already clarified is individual rights. From a CCPA perspective, you have 45 days. From a GDPR, you have 30 days. And we're going to march forward from here and talk a little bit about notice. So the whole idea of a privacy notice is to say what you do and do what you say. So that takes a village in a company to make sure that everyone is aware of all the information that we're collecting, where it is, what categories, what third parties it's going to, so that we have an accurate notice. And likewise, the business has to communicate to us about what they're doing. It needs to be a dynamic process to make sure that we're always in sync and communicating properly. So websites often have a lot of tags on them. These tags can cause site latency, malware can come through them, data leakage, and we also need to know about all of the tags so we can manage our cookie banners. So we have to have a cookie banner, it should have a cookie policy, it should also always be reflective of all the cookies and pixels and ad tags and analytics tags and measurement tags and strictly necessary tags. It should have a list of all the tags that we have on our websites. And this is a really important piece from a lot of the GDPR findings. The consent has to be received first, then the cookie should fire. So when the Bavarian regulator went and did their cookie sweep, they found that they weren't always listing all the cookies. They didn't have the cookie fire after the consent was received. There wasn't always the ability to opt out. All of that is extremely important. So making sure you have a good handle on the tag process will help manage this cookie notice, and there's also a variety of tools to help you. So that's a lot of information. How do we do this? Well, first, you've hopefully heard the theme by now that compliance is an ongoing proposition. It's not a one-time do our data inventories, put them in a digital file, and we're done, and hope that our teams come to us. We really have to be active and make sure that privacy is thought of, just like you think about how much a project's going to cost, or what IT resources need to be involved, or how many people you need on that project. We also want to think about the privacy impacts along the way. So doing that, it's really about building a strong foundation. If you were to build a house, or when my kids build Legos, they don't, poof, just put them all together magically and have their design. They have to start with the foundation. Once they start with the foundation, you keep building it layer by layer by layer. And then finally it matures, and now you have a robust program. And from there, you can continue to build upon it and always include updating data inventories, performing privacy impact assessments, and incorporating those privacy principles throughout the organization. When you do that, that will always help ensure compliance overall and make sure that we know the flow of data. The heart of these laws is knowing data in, ultimately throughout the whole organization until it leaves the organization at a very simplistic level. Now, it's really complex in organizations that have numerous databases, multiple employees, different geographies, numerous parties. It can get complicated, but at a very simple level, if we just start with the foundation of asking the right questions, then we'll be able to have a strong program. So with that, I want to create another poll question here. How would you describe your vendor management process? All right, we're going to take just a few more seconds here. All right, so I'm going to close the poll. We're going to share, and around half of you have an informal process, and about 38% have a formal process. So for those who don't love vendor vetting, now is a great time to really formalize it. The whole, as I've mentioned, the heart of these is to truly understand what data is coming through your organizations, and we are responsible for the parties that we send the data to. So it's important that we can vet those vendors and have a strong process in place. Often because we are integrating our various technologies, we want to know where that data is going and do they have the right measures in place. If we perform privacy impact assessments, think of it as a questionnaire asking the who, what, why, when, where questions internally, and as part of that process should be the integration with a vendor assessment. We'll have a good understanding of what is happening with the data, and we'll be able to manage our privacy and security risk obligations. To really bring us to the idea that trust is the basis of privacy. As we started this conversation, our customers are providing personal data to us. We want to know that what we're doing internally is honoring that virtual handshake with them with the data that they're providing to us. So what does that mean? Kind of briefly, we've talked a lot about these already, but it really goes, privacy is beyond just protecting the data. It's about the use and knowing where that data is at all time, who owns it, what companies and third parties have our data, how we've performed our vendor assessments, ensuring that we have performed them when we feel comfortable with that, where the data might be going. We can utilize privacy management software to help us, and maintaining this on an ongoing basis will help us, if we can do audits, we can help ensure that our processes and required documentation are always updated, which kind of helps the flow of all of these other parts, and will help us maintain and determine where we need to maintain reasonable security practices. So what are some action steps you can take today? Well, if you've complied with GDPR, congratulations, that's awesome, great first step. We're not done. There's still some more that we need to do to comply with CCPA. If you've done your data inventory, I highly recommend that you do update that. If you have individual rights processes and plans today, it's important to review those, make sure that they are actionable, really try and test those processes out, and ensure that everyone who needs to know knows what to be doing. You should have a pixel governance strategy, and when I say pixels, think back to cookies, and do a tag audit. I assure you there are probably tags on your site that, again, might be causing site latency or malware coming through that you want to review. Educating and training the workforce, that is extremely important, not just on security measures, on privacy and what they need to be doing day in and day out to comply with GDPR and CCPA. Making sure all your internal policies and procedures are up to date, and who is responsible for this in the company, and what other tools or resources do you need? Do you need privacy management software? Do you need consultants or attorneys to help you with that? At the beginning, when you registered, we asked you for what were your biggest challenges, and we thought you might want to hear from all of them. So understanding CCPA, right, being clear on the rules, understanding does it even apply, who's in scope, how do you manage all of these people, what is a good process in place to actually do a privacy impact assessment, how do you find all of this data and get buy-in and engagement. So with that, we want to ask our very last poll question, which is, how do you stay on top of laws like this? So I just want to take a moment and ask really quickly how you stay on top of laws like this. And I'm going to close the poll real quick and share. It looks like a combination. So a lot of you like webinars like this, but you also really like internal resources, videos, and blog posts. So thank you for sharing that information, and a little bit about how can BetterCloud help you? Well, BetterCloud has the ability to help you control the access to your data by enforcing a least privilege model. The less number of people who have access to your data, the better off you'll be able to be in securing that. Helping you manage with individual rights of the right to deletion, ability to be able to discover where your data is and delete data, the ability to deploy advanced alerts and policies to maintain reasonable security practices, and again, one of those other individual rights, the ability to help you with data portability, because you'll know the ability to centralize and locate your data. And if you have any more questions, you'd like to see a demo, come visit bettercloud.com/CCPA. And with that, I'd like to open it to any questions. And at the same time we're opening for questions, I'm going to put sort of some of these resources out there. If you want a CCPA compliance guide, come visit my site, redcloveradvisors.com/CCPA. If you want more information on a product and solution to help you with CCPA, come visit bettercloud.com/CCPA. So I'm just going to check here to see if there are any questions. And if you've thought of a question or we breezed through something and you don't want to ask it right now, by all means, please reach out to us. Our contact information is going to be on the next slide that I have here. Here's our website. Again, just do /CCPA for either of us to be able to get the information that you're looking for. Here are our numbers and our email addresses, and we'd be delighted to help answer any questions that you have. And also, if any of you are not a BetterCloud customer yet, but you're interested in learning more and leveraging BetterCloud for your CCPA needs, I highly encourage you to get in touch, again, by going to the website or one of these emails or phone numbers here. I know we went through a lot of information today. We certainly hope that you found it valuable. We appreciate your time in joining us this afternoon. Thank you for Red Clover Advisors and for BetterCloud. And I hope that everyone here has a fabulous rest of the day.